All right, welcome back. Now, for that journey that I mentioned, I am so excited. Next up, here in the Changing Lawyer Virtual Summit, we are delighted to have Professor Richard Susskind, OBE, author, speaker, independent advisor, discuss what the future has in store for the court's dispute resolution and for work. Joining us from just outside of London, let's take a journey together with Richard, with Haley, into our future.
All right. Well, I'm Haley Altman. I'm the Global Head of Corporate Development at Litera, and I'm thrilled to be leading this next session at the Changing Lawyer Summit on behalf of Litera. And joining me today is a guest that really doesn't need an introduction. He is a leading expert, speaker, writer, author. He has worked with governments, advises law firms. He wrote The Tomorrow's Lawyer and The Online Courts and the Future of Justice. So I'm thrilled to have Richard Susskind here with me today. Richard, welcome to the Changing Lawyer Summit.
Haley, thank you very much. And thank you, Litera, for involving me.
Yeah, well, I think it's really, great to talk to you now. I mean, you kind of really had a kind of a prescient thought. You've been talking for years about online courts and the importance of evolving our access to justice. How do we not just automate different processes, but innovate? And in 2020, you wrote a book around, or published in 2019, is that correct? Online Courts and the Future of Justice. And it's become even more important as we've had to move to this remote world and online courts being the only way for people to access justice. So can you tell me more about your kind of passion and your interest in moving to the online court world?
Yeah, this has been in my mind for about 40 years since I got into the whole field of legal technology when I was a legal undergraduate at Glasgow University back in the early 80s. And I felt then, as I do now, that we could do a better job in the delivery of our court services and that technology could play a role in helping. But if you fast forward to 2019, you're right, I wrote this book, came out in November. No one, of course, knew that a couple of months later, COVID would be arriving. In fact, the book wasn't directly about the kinds of remote hearings we've had. I'll say a little about that in a second. But it was talking about thinking differently in the way we offer access to justice. And then, of course, COVID came, and I've been tracking, we've been working on a project called Remote Courts worldwide. You can have a look at that, remotecourts.org, where we can now see 168 different countries have moved from physical courtrooms to remote hearings, either hearings by video or by audio, or sometimes just hearings on the process on the basis of the papers alone. And so we have seen this remarkable change in a very short period of time. I want to argue against those who are now saying the future has arrived. However, I don't think dropping hearings into Zoom is as pundits would want to say, a fundamental shift in paradigm. I don't think working from your kitchen table overcomes the major problems we face, because the problems we face very simply are these: that even in the most advanced jurisdictions, if you take civil disputes, for example, our process takes too long, it costs too much, it's unintelligible unless you're a lawyer. And increasingly for younger people, it's out of step in the digital society. So the question I asked in the book, and we've had to ask all of ourselves over the last year and a half, is court a service or a place? Do we really need physically to congregate in the one place to resolve our differences? Or might there be, in a digital world, different ways of resolving legal disputes? So that's the premise underlying my work.
Yeah. Do you think that when you see what's happened now in courts that have really done it the right way, are you seeing people that are kind of taking it a step further than just going to Zoom? Or is it really more just like we're kind of replacing one place with like kind of an online place? Or is there any courts that are kind of really taking it a step further?
It's a great question. People often say that COVID has accelerated technology. And I want to draw on the distinction you mentioned earlier between automation and innovation. Automation being computerizing or systematizing how we work today, and innovation, in my terms at least, using technology to allow things to do things quite differently. Now, I think during the COVID period, strangely enough, although it's been radical, and in England we haven't seen such a change for 150 years, it's still been automation, still the same people involved, it's the same rules of procedure, same old problems, delays, complexities. And so I believe what we've seen through COVID is an acceleration of automation. Understandably, we've been trying to keep the ship afloat. So we're saying, how can we use technology to keep what we're doing today still working? We've automated. We've been asking far less during this period. How can we use technology fundamentally to rethink the way we deliver the service? And so I say COVID has accelerated automation, but decelerated innovation. And I have found very few examples of jurisdictions that have rushed to automate who've then neatly segued into innovation. It may well be, ironically, that this advance to automating and going into video hearings will hold back the more fundamental transformation, because people are still bedding down this, what was regarded at first as temporary approach, broadly speaking, video hearings. So the real innovation I see is still coming from countries and jurisdictions and initiatives that predated COVID. And the best example, I think, remains British Columbia, its Civil Resolution Tribunal. And what's interesting about that is it's not that you have by and large, it's not that there's a hearing only it's done by video, it's that it's an asynchronous form of process. So synchronous communication is communication where the people communicating need to be present at the same time. A phone call, a video call, a meeting. Asynchronous is like a text message or an email, or indeed a traditional letter, where you both send and receive at your own convenience, but you don't need to be available at the same time. What fascinates me, and is the subject of my book in many ways, is asynchronous hearings. It's not really a hearing at all, it's asynchronous process. So the idea is that the evidence and arguments are submitted electronically, almost and very primitively could regard as an exchange of emails amongst a group of people. The parties have an opportunity to say their bit, and the judge delivers his or her decision in kind. The whole process done asynchronously online, and that's what you've got in somewhere like British Columbia. But that's not the natural next step for people who are in video hearings. So I say that COVID in many ways is a springboard because it's opened minds to new ways of working. And it's changed some minds, but whether or not people will either, and what I'm seeing is a slightly polarized view, people who are saying, I don't like this video hearing business, let's go back to the old ways of working to do that, or others saying, gosh, this is amazing. I don't know why we've ever done it any other way. And I see it slightly more nuanced than that. I see, if you look and say by 2030, we'll have a variety of ways we can have a hearing. We can have a physical hearing, we can have a video hearing, we can have an audio hearing, we can have a hybrid hearing. You might even have a hearing in virtual reality, or you might have an asynchronous process. And what we've got to try and do in terms of what justice and proportionality requires is make sure we're matching the right type of hearing to the right kind of case. And we're fairly early in our thinking about this. Most people would say that these alternatives to physical hearings are useful for procedural matters and preliminary matters, but the full trial, the main hearing, has to appear in person. And that's the argument for the defense, as it were, defense of the status quo.
Yeah, well, I think that's what you hear is like people think you have to, if you're going to change a process in order to innovate it, you have to change almost the entire process. And so they like look at the entire hearing and they're like, but how could you replace that like formal in-person oral arguments, when you're realizing, well, you don't actually have to change necessarily every single part of every single case to have meaningful impact. For a lot of people, even getting the ability to have any sort of access to the justice system, you actually give them a better forum, and having those different types of communications, different entry points. It's not changing every aspect to be innovative. It's actually, you can innovate parts of the process to allow for a change.
I think that's right. But one fundamental issue that I'm not sure anyone's really happy to confront is that our laws of procedure are very complicated, and particularly if you're not a lawyer. One of our top civil judges over here once said, any system that's got a 2,000-page user manual has got a problem. And that he was referring to the White Book, which is our civil procedure manual. And most of us who call for the use of technology in the court system are simultaneously saying we have to have an overhaul, a great simplification of our rules and procedures. Indeed, if we can, we need to embed the rules and procedures in the system so people don't need to learn them to comply with them. And that is a major change. All of this brings us to the issue, I suppose, of design thinking, that historically systems have been designed by lawyers for lawyers. And now we're thinking, actually, these systems have got to be designed by people who understand design for non-lawyers, because if we're going to offer genuine access to justice, I think most of us now agree that that's going to be through some form of self-representation in the court system. And so we're designing a system for people who aren't lawyers, which is a huge challenge.
Right. And who helps solve that problem? Is it like, I mean, you start to see different things in the tech industry, the do not pays, there's a number of other ones, Hello Divorce, like different types of applications that are trying to give people access, to different parts of the legal system through technology, oftentimes sometimes developed by lawyers, but sometimes developed by people that are actually experiencing the problem and want to provide that way to access. So where is it kind of, you have to come at it from different angles, like some people trying to bring technology to it, do the rule, where does the change really take place?
So far, most of the innovation has taken place beyond the court systems. So this is one of the very interesting questions. It seems to me that you could have some of these new forms of dispute resolution either wholly embedded within a court system or state system. You could have it wholly in the private sector, or you could have, as we're looking at in England and Wales, some kind of private-public partnership. So far, the ideas, though, tend to be coming from, it might be scholars, it might be entrepreneurs, it might be disgruntled users who've had a terrible experience or motivated to change. We've got a whole hodgepodge of input just now, and somehow this needs to be brought together if we're going to do it at scale. Because you're right, in the systems you mentioned, they are, well, you haven't said, but it's a slightly piecemeal response to there's a pervasive societal problem in access to justice. But this, I think, is characteristic of the early stages of many developments in a market. You have people on the edge and on the fringe beavering away very intently, and then at some stage people come in to think about scaling it. And that's, I've just been asked by our top civil judge to chair a group called the Futures Group over here to look at our court system in 2030, and we've got lots of different people providing input, but hopefully we'll start thinking about this more systematically and strategically, because I think that's the point. We have to move from being short-term, tactical, reactive to something long-term, strategic, and proactive, embedded within our system. We haven't got that yet. I was
going to say, I saw that Futures. It's got an amazing group of people from all different backgrounds, bringing in the law firms. Like, is that what it takes to find that change? Is having the broadening the coalition of people looking at the problem, the different voices and opinions to try to kind of come to that kind of next stage of development?
I think that's right. It's what people call cognitive diversity there. That I mean, traditionally, I don't know how it is in other jurisdictions, but in England and Wales, when we've got a new thorny challenge, often either a single judge or a group of lawyers is put in the job. And the reality is that they're often incredibly bright and able people, but they're all thinking the same way. And they tend to go in for what I would say automation. I mean, a related point I make is that all transformation projects end up as efficiency projects, that what you find is people are asked to transform, but when they get together, actually, they're so deeply immersed and committed to the old ways of working that what they tend to go for is the efficiency gain. So what we're trying to do, and we've not finished putting it together, we've got about 10 people, is have people who are coming from different perspectives. We definitely need to have someone in design thinking, and we also need to have more representation from users. Now, I'm pretty confident that the more diverse group you have, the better chance you give yourself. But it's a tall order, because what we're taking on, and there's an analogy, of course, with traditional legal service as well. What you're taking on in court service is something that's deeply embedded in our society, in our psyche. And you have some very talented, committed individuals who are, as I said, steeped in the way of our current ways of working and perhaps reluctant to change.
Yeah, no, I mean, I think it's like that ability to get people to like kind of try something. It's like you have to acknowledge that there is a distance between when you start doing something new in a new way, that it's actually going to take you longer so that you can get to the part where it actually, you've crossed the chasm and it's now something that you can embed in. And getting people to take the time to try to make that change and take that first level of inefficiency is sometimes really difficult.
We also don't really have the tools or the methods. If you can compare it to medicine, and we've been exposed so much over the last 18 months, tragically, to medical method. But if you have a look, for example, at what's written about the future of courts, from blogs to op-eds to speeches by eminent lawyers and judges, very few of these, for example, are peer-reviewed. They're just people speaking from anecdote and deep experience, but nonetheless, it's not systematic and rigorous. What's the equivalent in law of the randomized control trial that we have in medicine when you're comparing a placebo with an actual drug? How do we set up some kind of, if you'll forgive the pun, trial to compare what went on in a physical courtroom with an online version of that? We're at our early stages of this. So what we tend to do is default to our old ways, because people say, well, there's no evidence that what you're suggesting is going to work. And I say, well, there's no evidence from the future generally. But I would also say that where we are today, our current systems and setup is not the result of a recent evidence-based policy decision. It's just where we are.
It's just the way it is. It's just the way we do things.
And so I think we need to think more deeply about how it is that as we evolve and develop new ideas, we can reliably and responsibly compare them to what we have today. And also we have to bear in mind, what is it we're trying to develop? So for example, if you're trying to reach, as I try to reach, what I call the latent legal market, that's to say people who aren't served at all today, the test isn't whether or not it's better than the best court in the land or the physical court. The test is it good enough? And when is good enough good enough? These are questions we haven't really thought through. So we're very much at the foothills. We're a few, maybe 20 or 30 really good experiments and pilots and early operational systems around the world. It's going to take a decade before this beds down into something that is systemic change.
Yeah. Well, I think about it, from so now I'm a lawyer by training, so I was an M&A, so I'm on the transactional side. The courtroom is not a place that I'm as much comfortable. But when I left to start, I left partnership to start a tech company to try to solve those problems that I kept seeing. And so I started Doxley, which I sold to Litera, which is how I'm here where I am today. But one of the things we did when you're trying to change how people would do a transaction and try to sell into those law firms, in the beginning, we really kind of struggled to kind of get them to understand what we were doing and how we're doing it. And so we, to your point, that evidence-based kind of methodology, we started with, kind of Excel sheets saying, hey, if you could save these hours, this would give you this ROI. Then we actually started just doing straight out time studies, and we would give them like a work product, like, hey, do this. This is the way you would normally do it. Now, here's how much time it would take you this way. And one of the, every Doxley employee, no matter what your what you did in the company, you had to do this as well to see the pain of what it was, the way people used to do it versus like how they could do it within technology, because then you almost have to like show them the change, the value creation. And so it's hard for like systems where the person changing it is disconnected from like who could develop the technology sometimes. But I do think from a general, like kind of future of law, tomorrow's lawyer type perspective, like from a vendor perspective, if we want people to start innovating, we want people to start changing, you have to, and especially if you want to change a process, you have to show them, find ways to show that kind of that savings, that ROI, that those numbers that people can like appreciate.
I completely agree. I often say that evidence speaks louder than argument. And so if you actually show people concrete evidence that they can trawl through, then that, in a nice sense, they can look through in detail, then that speaks more powerfully than simply raising arguments that this would be a better future. But you do raise, and I'd be interested in your feedback on this, you do raise an interesting question that if you take what economists would call a task substitution model and approach, you say, well, let's look at M&A and let's look at some of the bits we do inefficiently. Let's do some time studies and let's show how it is that we could do that particular task more efficiently. That is still, and it's not a criticism, it's just an observation, it often still tends to be a form of automation. But the one of the upsides of automation is you can measure it and compare it more accurately. Let's take just hypothetically the idea of a due diligence exercise. And so much work on AI and technology just now is on document review in the course of due diligence. You know far more about this than I do. But you could say, well, rather than automating and making more efficient the due diligence process, why don't we create an insurance product? And I think this is already done, but and you and I have discussed this. Why don't we create an insurance product that obviates the need altogether for a due diligence exercise? Because after all, what people are wanting from a due diligence exercise is somehow to try and judge, evaluate risks or cover the risks or protect themselves and so forth. Now, that's an innovative idea in the sense of it's an entirely new way of doing it. But it's far harder to compare that. This is my point in the question. It's far harder to compare that to how it is you do it today. So automation, I think, only takes you so far, but is measurable and more compelling. Innovation can be more transformational and fundamental, but in the spirit more of an entrepreneur, it's very hard to show the business case at the outset.
Yeah. Well, I mean, I think it depends on kind of how far you're taking it. So if you're saying like, I want, and that's the things I think we're all challenged with, because when we started, we looked at it like, okay, let's look at the process as a whole. Let's not look at one part. Because if I can automate like how you create a packet, that's valuable. But that still doesn't change the fact that someone just created 400 signature blocks. Yeah, they put them in a packet better. What if the technology just did it? Like, it's the same thing over and over. Like, so, you know, so it's like you try to take people a little bit step further. But I mean, I think that's actually part of the things that we've seen in COVID is that people are saying, okay, wait, there are some basic things that we do that, to your point, it is an efficiency. So I think there was first a return to that, like kind of how are we more efficient? How do we take those paper-based products? I used to remember when I first started my practice, I would take a ruler and I would like kind of go through the document to see like, okay, is this term defined? Is this section reference correct? And now when you're at home and you can't print all these documents because you don't even have a place to properly shred them, you had to like go back and say, okay, what technology was available? Like, how could we do this differently? But then you also realize, wait, I could actually collaborate with people from across the world, and we could do deals together. And we can do things differently. What technology is out there? And I think it's like it's that first step of here's what's possible. Like, we can take this further. Now someone's got to come in and say, okay, let's change the process. Yeah. The question is, who can do that? Who can motivate people to change the process?
And we've actually had relatively little of that, not just in law, right across the professions. I've just finished updating the book I wrote with my son called The Future of the Professions, which we published first in 2015. Wow. And just last week we finished the new update. And we do make the point, we've seen no major professional provider self-disrupt. We've not seen really an Uber or an Amazon in the professions. We've seen lots of really good examples of some professional work being done differently, but there's not yet, and one might say that it will never come from within the profession. We've not seen some massive game changers. And that's why I say even the COVID courts, this way of working remotely, that's not a huge game changer. It's one of a number of incremental improvements. But it may well be, but the nature of the professions, we will, and I've written this, I'm not sure entirely believe it because I think it could happen another way, but I've predicted it's more likely to come through what I would call incremental transformation rather than overnight revolution.
Yeah. As you've kind of gone back to the book and looked at the future of the profession and how you kind of changed your guys' viewpoint from 2015 to now, especially with what's happened with COVID and that remote work possibilities, what do you think are some of the biggest changes or the biggest new insights in terms of how you view kind of that professional services world evolving?
So we looked at a whole bundle of different professions, and the answer is not the same for each. So we looked at law, education, health, audit, tax, architecture, consulting, journalism. We even looked at the clergy because they're all, we thought, quite interesting, different examples. And if you look at something like tax, then the globalization of corporate tax compliance systems is going at a remarkable rate. Audit is fascinating because in everyone's hearts, well, this might not be true, in most people's hearts who've given this serious thought, they know that the idea of a traditional financial audit, which involves people once a year looking at a sample of transactions, they know that that could be supplanted, replaced by real-time review of all financial transactions. So real-time 100% audit, I believe, and others do too, is technically possible today, but for cultural and regulatory reasons is likely to, and commercial reasons, is likely to take some time to come through. So in tax, you're seeing in some areas pressing ahead quite rapidly. In audit, it's still about audit automation rather than audit fundamental change. The clergy has been interesting because during this period, the COVID period, people had to follow their faiths and pray remotely. And that's actually given rise to some very interesting effects about larger communities coming together online and some revision of standard views of what it is to pray and how it is to pray within a community. There's been no single answer. Education, of course, has been changed beyond recognition, really, by online education. We've talked about the law and courts. And then in areas such as architecture, we've seen fantastic advances where systems are essentially giving rise to designs that in human beings would say are highly creative. Algorithmic architecture is emerging. There's no single trend. We've seen an increase in the pace of technology. We've seen an increase in the uptake of technology. We've seen, I think, a greater open-mindedness, so that in 2015, judges were saying you couldn't hold a hearing remotely. Doctors were saying you couldn't see a patient remotely. Teachers are saying you have to be all in the same classroom. So there's these, and this, to this extent, COVID has indeed accelerated. But to stress again, we've seen no fundamental disruptors. So our belief is the 2020s is the decade during which AI will encroach on and take on more and more of the tasks of human professionals. But it won't consume entire jobs. What it will do is take on various tasks within the jobs. So the point we make is that what we're seeing is the era where we are, I think, as professionals now beginning to build the systems that will replace our old ways of working. And that then gives rise to a very interesting question for anyone in the professions. Do you seek to compete with these emerging systems or build the systems? That's your career choice, folks. Everyone listening in. By competing, you're saying, yeah, we know about all these systems that are coming through, but they don't really do what I do. And what I do, no machine can ever really do. So I'm just my career, and thereby I think you're swimming against the tide. But in any event, I think it's a privilege to be alive at a time when you can actually be involved in building the systems that can replace our old ways of working. So we're beginning to see, and this is a change within leaders in the profession rather than maybe the technological enthusiasts. The leaders are now recognizing this is not just a mild blip at the edge of the radar screen. This is going to be center screen. And what I'm trying to encourage, we're trying to encourage, is people to rethink the purpose of what they're doing. So as I often say to doctors, that patients don't want doctors, they want health. So the question isn't how will AI affect doctors? It's how in the future will we be able to ensure the health of our community through emerging techniques and technologies as well as human beings. But we shouldn't be, the question that people often ask is, what's the future of lawyers? What's the future of courts? What's the future of doctors and so forth? I say that's the wrong question. The question you should ask is, how in the future will we be solving the problems to which doctors, lawyers, and courts are currently our best answer? Because if you ask yourself, what's the future of lawyers, you're already putting lawyers in the answer.
Right. Well, and that, I mean, I think that's such a great point. And it's, one of the things we've seen is, there is a lot of technology out, and, if you think of in different areas, but the amount of work that's available, like, during COVID, the amount of work that law firms have did not go down. In fact, it's increased to the point, and especially in the transactional side, where firms are actively having to turn down work because they do not have the associate resources, the attorney resources to be able to do it. And, you have these entire areas where, the resource constraints that are starting to happen. People want to move to different firms. They want to have access to technology. They don't want to do it they don't feel the need to have to do it an archaic way that does not make sense in order to do their job. So that's a big thing too.
I agree with that. There's a number of things there. One, I'm not sure smaller firms have enjoyed the same kind of success.
Okay.
The great majority of firms worldwide are smaller firms. It's certainly true the top 200 or 300 law firms around the world have enjoyed great success. And that leads me to a second point. As I often say to partners conferences when I address them, it's hard to convince a room full of millionaires they've got their business model wrong. The reality is that no amount of my chatting about different models can actually detract from the fact that these firms are phenomenally successful today. So it'll be external factors that are likely to bring about their change. So in dispute resolution, if there is a major shift away from, for example, physical hearings, then these firms will need to change their dispute resolution practices. There's no doubt about it. The extent to which and the time with which remains unclear. But the third thing to say is that although there is, of course, this huge increase in demand, I do still hear from clients again and again that they are under phenomenal cost pressures. Right. And it is always slightly bemusing for me to see the big law firms announcing their yearly increase in profits when I'm doing research with in-house lawyers that's saying they are struggling to afford the legal and compliance work they need to do. And so what we really do need in the marketplace, I think, is new competition and price competition. And that's why it's interesting to have such a fascinating range of legal tech startups. It's interesting to have the big four in the market. It's interesting to have the ALSPs. Now, none of these has really affected the work of the major top 200 firms in a significant way. I wrote a piece with Neville Eisenberg on this in Harvard's online journal of practice, and we were quite criticized for this, but we remain steadfastly of the view, although there's amazing work going on in startups and ALSPs and the big four accounting firms, it really has not thrown most of the major law firms off course. And this is not a criticism, it's just an observation. And so I think, again, as across the professions, it's a long game rather than an overnight shift. In some other sectors, you do see very rapid shifts, whether it be Airbnb or online selling of goods and so forth. As I say, for cultural and technical and commercial and regulatory reasons, the professions are likely to change less quickly.
Yeah, well, I think in the U.S. now we're starting to see states that are allowing ownership of law firms to be non-attorneys, and so I know that's we're kind of a little bit later to that kind of shift, and it's not across the board. It's still state by state. What do you think of the impact of kind of shifting those kind of ownership guidelines and different things like that on? I mean, I know that more broadly around the world that's already allowed, but what about does that shift in the U.S. have impact on?
Yeah, it's not that widely allowed around the world. I mean, in England, even in my native Scotland, it's not fully allowed. So again, I think it's early days. If I can mark my own homework, this was something I predicted in Tomorrow's Lawyers, that the US, despite, oh my goodness, vociferous arguments at conferences to the contrary, I said in the early 20s, I do believe that you'll begin to liberalize. And the damn wall has been broken. So I don't think it'll stop with Arizona or whichever other states are interested. But I think it's a good thing. I think it's good. I've always said this, that we should thrive and survive as lawyers because we bring value to the market and those we advise that others don't, not because we pull up the drawbridge or draw fences around what we do. This goes to the heart of what our book in the professions was all about. We call it the grand bargain. We have this rather strange arrangement in our world that we give exclusive rights to certain occupational groups to do certain things. And it's understandable, for example, that we only allow surgeons to cut our bodies open. We only allow certain kinds of accountants to attest to or to confirm the accuracy of financial reports. And we do all of this in the interest of the consumer. But we cannot pretend in the legal market when so many people are alienated from and don't have access to legal services, that it's somehow in the interest of the consumer for these people not to have access to lawyers. I think it's unfathomable. More than that, what I said in the US is, as in jurisdictions, and again, this is a long game, but as in jurisdictions such as England and Wales, when credible alternatives emerge, I think it will put the US at a competitive disadvantage, not being able to, for industry and commerce, to turn to alternative providers. So my guess is through the 20s, we'll see more and more states coming to their senses. But there's an important, I think, moral issue here that we should not, in the name of self-regulation or whatever other justification people have around the world, we shouldn't be allowed, it seems to me, to be excluding services from the needy. Now, for many people listening in, or perhaps in major law firms, that might not make much of an odds. But I want to say that at one stage in your lives, when you're in law school, you really did care about access to justice. You tend to care about it less as you progress. But I want people to be more aware of this, that overwhelmingly, most people in our world don't have realistic access to lawyers and courts. And we don't help ourselves by saying that only lawyers who can charge a certain amount and work in a particular way, they're the only people who are qualified, who are able to help you. So I've seen so many credible, exciting online legal ventures, charitable legal ventures in the United States being struck down as contrary to bar regulations. But for me, it just doesn't make sense.
Yeah, no, I think that, I mean, and to your earlier point, while large law firms, kind of continue to see growth, small law firms suffered, many kind of went under in the solo and very small, but, there is this need. And so there's this gap of how do you pair. I've talked to Kristen Sunday over at Paladin a lot about this. Like they're so much focused on matching, kind of pro bono work with firms, but you have all these small firms that if they could just access, there's so many people in need of legal services, but that ability to kind of find ways to match people to the legal work that needs to be done. There are people that can do it, but there's not systems to actually help them get access to the work or the people that need it.
And it's also worth saying that it's not just individual citizens, it's small businesses, small, medium-sized businesses who, with a wing and a prayer, often just have to function without lawyers and have no real sense of the full range of obligations they owe, of the compliance risks they face, of the contractual exposures, of their susceptibility to dispute resolution. And that's why a business like LegalZoom has done so well. It's not just about individuals. So there are different ways. The LegalZoom model is the one-to-many model, where you have one body of content that can be reused by many, whereas the traditional model is one-to-one consultative advisory service, and you charge for time. So we are seeing emerging different ways of working and delivering services, and I think that's exciting. The big question for me is whether or not that might also extend to big law. Is the access to justice narrative, is the one-to-many narrative just for the traditional excluded? Or, and I'm seeing hints that there's an appetite for this, or might major legal departments say enough? A lot of what we do is everyday law. It doesn't need handcrafted afresh every time. And so that's why initiatives like CLOC are so very important, that you're seeing people who are more focused on operations and process, on standardization and reuse of knowledge. They're coming together, not just with this shared passion for working differently, but actually for exercising their collective muscle. So that, I think, is another reason to think we may see quite a big shift. Yes.
I was just going to say the One NDA project. I'm interested to see how that will kind of, having a single NDA that everyone can sign. And I think it's now actually been commercially used, where people have actually now used and signed NDAs through that process. An NDA is not something that needs to be negotiated for, hours on end.
And that takes us back, though, to our earlier discussion. It's not just about technology, it's about the substance as well. And so just as I was saying, you need to simplify court procedure, then the interesting thing there is that it's about the standardization of content as well.
Right.
It's the variation in content that often, a variation in substance, delivering perhaps the same clutch of legal rights and obligations, but doing it in different ways. That variation of itself, that variety perpetuates a more complex, a more diversified, a more expensive way of resolving everyday legal problems. Now, except for bet the ranch deals and disputes, people want their gladiators and they want their superb lawyers and don't want to diminish that in any sense. But we do know for everyday compliance work, for everyday contract management, for everyday legal risk management, there should be a fairly set of standard tools and facilities. So they'll emerge through the 20s, I reckon.
Yeah, I think you've seen the kind of the productization of law, like different things like the MVCA, which is a venture capital association forms, different things around different document sets and corporation documents that you can start to find, through LegalZoom or other places where you can actually start to get those forms, one NDA. I mean, it's still there. Things are still, I think in those areas, you start to see people shift to more of that alternative fee arrangement because things should be able to be done for a more understood price point. And so that's the question is like, how many more of those things, whether it's, I think you see people in firms trying to figure out how to centralize and understand the knowledge work that they have within the firm. Like what is that knowledge basis that they have that they can reuse? But standardizing across firms or across a type of practice, a matter type, I think that's still a ways away from us.
I think that's right. There is another further development I wanted to mention, and that is where we embed content within our clients' working processes. So I'm going back to big law again. If you take, say, the very big financial institutions, the banks, the building societies, the insurance companies, and you take huge manufacturing companies, what's common to all of them just now is the extent to which they're introducing automated workflow, standardized working practice, and so forth. And on one model, there's no legal content to that. When you need a lawyer, there's a lawyer in the loop, a human lawyer in the loop. Mm-hmm. But what I've been looking at, and others are too, is the idea of embedding legal modules within these working processes, and so that compliance is built in. And that's what I call putting a fence at the top of the cliff rather than an ambulance at the bottom. That's addressing legal problems by addressing the legal issues in advance. And so a whole new area of legal knowledge engineering will emerge, it seems to me, where you're designing new businesses. We can actually build in a large percentage of compliance. Now, it's still a legal job because it needs legal content, it needs legal analysis, it needs legal understanding, but that needs to be joined with a technical understanding of how to represent that knowledge or hold the content and embed it within broader systems. But that for me is a tremendously exciting future for legal services, where we're not wordsmiths or advisors on the edge. Somehow we're transferring our content and insight and expertise and knowledge into our clients' working practices and processes.
Yeah, I think that's such a good point. It's like that, and that's actually how you tend to show your value to clients, is actually understanding their business and how the legal knowledge actually fits into what they do. So, and as we're kind of coming up on time, like what is that kind of next stage that you think, like where does the innovation need to come from? Like, is it more finding groups that can come together to think through things? Is it more vendors or more people kind of leaving the profession to start these companies that can try to evolve things? Where do you, or the corporates putting pressure on law firms, where do you see the innovation starting to come from?
Well, just to say a little bit about innovation, because also in our professions book, we've reviewed that, and what we've seen as we've looked across the professions or professional firms is what we call the difference between first and second generation innovators. The first, in the broadest of terms, first generation innovators are still doing process improvement rather than new business models. They're looking at short-term tactical things rather than long-term change. A lot of it's marketing noise rather than substantive change. A lot of it's pilots rather than real full operational systems. A lot of it is modest in financial terms rather than serious revenue. Notably, a lot of professional firms that say they're innovative, it turns out there's only a small number of people who are innovative, and most of the partners are still doing their daily job. And most partners might understand it, but they don't feel it in the heart. And the second generation, everyone feels it. So there's a big point for me about mass engagement in the profession, that we have to move beyond the mindset that innovation is this peripheral activity. I'm glad we've got a unit who are doing this so I can get on to the proper work, to seeing that having a kind of R&D culture is going to be fundamental to the health and wealth of any professional firm in the future. Apple and other consumer electronics companies haven't developed the products that will deliver their revenue in a few years' time, so they're continually innovating and researching and developing. And if a couple of their projects land and that does them well, we have to recognize that we won't be delivering legal services in a few years' time in the way we are now. So we have to have that R&D spirit. So it has to come from within the firms, it has to reach across the firms, and it has to be also driven by, I think, a more discerning and demanding client base. Because I go back to this point, it's slightly inexplicable that clients complain, understandably, that they haven't got the money to pay for their legal and compliance needs, and yet the law firms are becoming more profitable. Your answer, I think, is the right one. It's basic economics. That despite their difficulties, the demand exceeds the supply, and that's why they can continue charging in the way they do. But I think that will shift over time as new competitors come into the marketplace. So that's the mix. We need leadership within law firms. We need mass engagement with law firms. We need a more demanding and discerning client base, and we need more genuine competitors in the marketplace.
Yeah, no, that's great. Well, this has been a really incredible conversation. I'm excited to hear more about, will there be more conversation around what's going on with the Future Group with the Civil Justice Center, or next steps on when the update to the book comes out?
Yeah, I've got a third edition of Tomorrow's Lawyers coming out. I've got an updated edition of the Future of the Professions. That the Futures Group will be pretty transparent, so we'll be reporting fairly regularly, and working online courts and remote courts worldwide continues. So there's a lot happening, and as far as I can, I try to make my stuff available. But what's so gratifying is there's so many more people now interested.
Oh, that's wonderful. Well, thank you so much for joining me, and everyone listening, please check out, it's remote courts.
Remote courts worldwide. It's at www.remotecourts.org.
Great, wonderful, and all of the wonderful books and knowledge that Richard's sharing. So thank you so much for joining us and sharing with everyone your insights.
Great pleasure, Haley. Thank you for having me.
Richard, Haley, thank you both for your time and for giving us a peek into our future. So interesting. Thank you again. Now, it goes without saying that the global pandemic has forced upon us radical change, causing us to exercise those muscles of innovation and adaptation in so many ways. I'm sure you agree that it's really caused the courts and law firms to innovate at an unprecedented rate. So our next panel will discuss the pros and the cons of technology and the gaps, and how legal tech innovators can help close them.
Hi.